All the attention he draws in the red zone, yeah, that's what's allowed.
Zoom user who just came on, can you please change your name to who you are so we know who you are, please? Please change your name so we know how to address you. No, I'm not talking to you, Mr. Huff. You're good.
All right, bye. Bye. Good afternoon, everyone.
Good afternoon, Judge. How are you doing today?
I'm fine. How are you?
Just letting you know I'm a one-man show today, so I'm zooming and I'm writing. So if I have to tell you to stop or hold, please. I'm not doing it on purpose.
Gotcha. All right. One man show, one woman show.
Yeah, one-woman show. And also I gave you the reset date for it's January the 7th, 2025.
January 7th, 2025. Got it. All right. We're ready to start.
Good afternoon, Judge. This is Officer Blunt in courtroom 2. I would like to ask, do we need position number 2, Mr. Collins? Do we need him because we were told he was an upgrade?
That is what I was told. He's been transferred to Superior Court. Is that correct?
I don't know. I didn't get that information. I got it. I got it through you, third party, but I have not seen no paperwork or physical information on it.
Good morning.
Ms. Russell, is that, I heard it was a felony?
Good morning. Yes. Well, the problem is we haven't received, I don't think confirmation that it's been taken by Superior Court. So I think it should be, but we did accuse it today. Just because we didn't get any confirmation that it would be a felony.
Okay.
We haven't got the confirmation. I'd rather go ahead and hear it and give them on, at least to make sure.
Thank you.
All right. Thank you. Anything else? Do we have any interpreters? Have the PDs interviewed everyone?
Yes, Your Honor.
Yes,
yeah. Okay. Great. All right.
Excuse me one more time. Miss Melanie, they're going to call you from courtroom 1 so that you can interview him.
Okay, yes, that's fine. I spoke to him for briefly, but I'll go ahead and.
Okay.
Okay, thanks.
We're ready, Judge.
All right. Thank you. Good afternoon, ladies and gentlemen. We're going to begin our Fulton County State Court Expedited Accusations calendar. And this is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, and we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. Be providing you again with that SAP reset date, which is January the 7th, 2025. I want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to also remind the defendants that you have certain constitutional rights, the first being that you have a right to representation, and all of you should know who your attorneys are by now and have spoken to them, so follow their lead. You also have a right to remain silent. Remember that anything that you state about the facts, the circumstances, and the occurrences of your case can and will be held against you. The state is here and they're listening, so once again, follow the directions or the lead of your attorney. All right. First case we have again is
Position number 14.
and that's Paul, is it Link? Charge of 1 count of battery family violence, 24 CR 008248B. Is that the case before us in courtroom 2?
Yes, ma'am, it is.
And who's the counsel?
Robert Wilson.
Are you private counsel or are you a new PD that I've not met maybe?
No, I'm private counsel, Your Honor.
Okay, gotcha.
The first level one,
Said first?
correct.
Okay, all right. That was pretrial. Mr.
Good
Will.
afternoon. I'm sorry. Good afternoon, Your Honor. Nice to see you again. Brief facts of the case is that on December 20th, 2024, the officer responded to 555 Summer Terrace Lane, Northeast in Sandy Springs in Fulton County, Georgia. The defendant called 911 to report that his fiance, the victim, was beating up on him. The officers arrived and spoke with both of them. The two are engaged and have been living together. The victim stated that she and the defendant were intoxicated and began to argue. And during that argument, that the victim attempted to separate by pushing him away from her. The victim stated that the defendant then struck her in the face while holding his phone. The officer observed visible bruising to the victim's face and that she had a busted lip. The defendant agreed that he should be the one leaving the location. The recommendation from the state is a signature bond through the pretrial services, no alcohol, drugs, or weapons, no contact with the victim, and the completion of an anger management course. I do believe that the victim, we were able to get in contact with the victim, and so if we could sign for the victim in this case, Ms. Morgan Cronin, Morgancronin, in accordance with Marcy's law, that'd be greatly appreciated. There is nothing further to add from the state at this time.
Right, thank you, Ms. Cronin.
Yeah.
I think we see. Yes, do you wish to address the court today, yes or no?
No.
Okay, all right, then you can keep your camera off. All right, Mr. Wilson, Attorney Wilson.
Hey, good afternoon, Your Honor. So I know Ms. Cronin said she did not want to address the court. I will proffer to the court. I have spoken to her though, and she's letting me know that she feels safe and all she wants is for Mr. Link to be back home with them. Jumping into the all factors, Your Honor, Mr. Link has been here in Atlanta since 2020. He's a college graduate originally from Athens, Georgia, and now lives in Sandy Springs. He's a manager at a State Farm agency here. Proud to say he is the top salesman in his agency, and so he loves the work he does there. His family is here in the Atlanta area. Some of his extended families here, so no risk of fleeing, Your Honor. His whole life is here. His fiance is here. His apartment's here. He has no criminal history, so he's not a risk to reoffend. Really, there are no witnesses other than Mr. Link and his fiance, so he's not a risk to intimidate witnesses. So with all that being said, Your Honor, we would, like Solicitor Pierre Thomas said, we would just ask for a signature bond.
All right, I'm going to grant the $3,000 signature bond through pretrial. And that'll be a level 1. And as far as this location, 5555, Summer Terrace Lane. Whose name is the location? Is it home or apartment? I'm not sure.
It's an apartment, Your Honor, that Mr. Link and the alleged victim, Miss Cronin, leased together.
Well, it just happened probably less than 24 hours or right at 24 hours. Usually want to make sure there's been the cooling down period and that parties are going to get through the situation. And state, you all said you did or didn't talk to her, but I just wanted to know what her contact level was. My inclination is to have no further contact because I want to make sure again it's been the cooling down.
We did in fact speak with her. She did state that she was not in fear of him and that she would like for him to return, but it is less than 24 hours, Your Honor.
If I'm able to speak,
Now, ask you that, and if you do, you have to turn on your camera, and I have to swear you in, and I'm only going to ask you 2 questions. All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
yes,
Okay, are you in fear of Mr. Link?
no,
Do you want to have any further contact with Mr. Link?
yes,
So you're telling me this is a one-time, first-time incident, and you're not going to have any future ones?
correct.
Okay. All right. Any cross-examination, Mr. Wilson?
No, Your Honor.
State?
No, Your Honor.
All right. I will allow Mr. Link to go back reluctantly, and no further violent contact. No drugs, alcohol, weapons, or guns while on bond. And I'm going to require you to take a 2-day anger awareness course through pretrial. And believe that's going to be it. Anything else? Did I leave out anything, counsel?
Nothing from the defense, Your Honor.
Nothing further from the state, Your Honor. Thank you.
All right, that's the order of the court.
Next is position number 5, Mr. Ferguson.
24 CR 008251A, Idris Ferguson, charge of 1 count of simple battery against a police officer or corrections officer, 2nd count of battery, 3rd count of criminal trespass and damage to property. Pretrial.
48. On probation, criminal damage to property. Got a 2024 arrest for entering auto and robbery. That was dismissed. Got a conviction related to a CWAC charge from 2023, 2022 FTA, 2021 trespass conviction, 2021 theft by taking trespass conviction, 2021 battery conviction, 2018 battery trespass conviction, and a 06 ag assault robbery by intimidation conviction. That's all.
All right.
Got a brief facts of the case is that on December 20th, 2024, the officer responded to a dispute at Grady Hospital, which is located at 80 Jesse Hill Jr. Drive Northeast in Atlanta, Georgia, in Fulton County. When the officers arrived, they spoke with the Grady Hospital security, Jesse Bell, who stated that a nurse, the victim in this case, Reagan Jackson, traditional spelling, was assaulted by the defendant inside of the MH mental health ward while being escorted off the property. The victim complained of injuries as a result of being kicked and stated that she desired to press charges. The officer spoke with the defendant, who appeared upset, and when asked what was going on, he stated that he slapped the shit out of her. While being restrained to the bed, the defendant then kicked Officer Braithwaite. The officer fell to the ground, and after being
Dan, can you do something with her?
Melnick, you're not muted.
Sorry, that was my dog.
Officer Braithwaite fell to the ground after being kicked and complained of shoulder and neck pains and had to be seen by officials at Grady Hospital. While at the precinct, the defendant began to kick a city issued desk multiple times, causing damage. Given the lengthy criminal history, 48 cycles to be exact, the fact that he was currently on probation for a charge this year and currently caught another felony charge this year. The state's request is a $70,000 surety bond, no alcohol, drugs, or weapons, a stay away from the incident location unless we're seeking services, being that the location is a hospital, no contact with the victim, and submitting to an MHET. And if we could sound from Ms. Jackson in accordance with Marcy's law, that'd be greatly appreciated, but there's nothing further to add from the state at this time.
All right, Ms. Jackson, Reagan Jackson. I don't think I see anyone by that name. All right, go ahead, PD, is it Geddes?
Yes, Your Honor. Nick Gaddis.
Okay, Geddes.
So, good afternoon, Your Honor. Mr.
afternoon.
Ferguson is a lifelong resident of Georgia. He has family in Georgia here who can be supportive of him and help him. He's told me his mother, his brother, and several other family members all live within the Atlanta area. He does have a GED and has a position working with a construction company. He's maintained employment with that position for the past 2 years. My understanding, after speaking with Mr. Ferguson and based off of the facts of the case, is that this seems to likely have been a mental health episode. He's expressed he has had difficulty maintaining access to his medication over the past several weeks. I think that may have been why he was at Grady in the first place. He has expressed to me that going forward, he has been able to ensure a way he would be able to have more ready and continued access to that medication. The witnesses involved in this case are not people that Mr. Ferguson knows personally. I don't see any concerns with witness interference or anything along those lines. I think something closer to a $2,000 bond would be more appropriate in this matter, Your Honor.
Well, I don't know, he has quite extensive history. And did you tell me he is or isn't from Georgia?
He is a lifelong resident of Georgia, Your Honor.
Okay. I'm going to grant a $6,000 surety bond. It's $2,000 on each of the charges. With that surety bond, he is to stay away from Grady unless he's receiving services and hopefully can safely receive those services. He's to have no further contact with Reagan Jackson. No drugs, alcohol, weapons, or guns, or unprescribed medication while on bond. Looks like I'm assuming he already has an MH plan or diagnosis. I would just state that he would stay on his medication and comply with what I think is already an existing diagnosis or plan of treatment. Is that true, Mr. Geddes?
That's my understanding, Your Honor.
Yeah. I don't know that he needs another one. It sounds like he just needs to be compliant with any plan or treatment or medication. And I think that'll be it.
Understood, Your Honor.
All right, thank you.
Position number 6 is Ford.
This is 24 CR 008241J. Ms. Ford, not sure how to pronounce your first name. First count is battery, family violence. Second count, cruelty to children in 3rd degree. Pretrial.
First.
State.
Your Honor, brief facts of the case is that on December 20th, 2024, the officer was dispatched to the location of 4465 Granada Drive, South Fulton, in Fulton County, in reference to a physical dispute call. It was approximately 40 minutes prior. They were called there before about a property retrieval call at the same location, at which point they met with the defendant and the victim. Upon the second arrival, they spoke with the victim, who advised that he and the defendant were involved in a physical dispute. The victim advised that he and Miss Ford had got into a verbal altercation over some pillows, and that quickly escalated into something physical. Ultimately, looks like the victim stated that there was a struggle for his cell phone because she snatched the phone from him when he was trying to record the incident. He advised that she began to throw haymakers at him, which she described as swinging at him and striking him with open hands and closed fists, causing several scratches to the right side of his neck and lacerations and contusions to the left side of his face. The victim stated that he began trying to put Miss Ford out of the house, but he could not close the door because she had laid in the doorway. He stated that at some point he jumped over her and ran out of the door. He also stated that approximately 4 random construction workers ran over to him while he was attempting to leave and began holding him down while the defendant continued to strike him and scratch at him. The defendant advised that her juvenile child, LF, was on the scene during the altercation. And I do believe that the juvenile child began to strike the victim with a wooden plank in the back of his head. The officers observed several lacerations and cuts and bruises to the victim's person, and did not observe any physical bruises or injuries to the defendant. The officers also observed the defendant's shirt as ripped off and torn in several places. The recommendation from the state is a signature bond through the pretrial services, no alcohol, drugs, or weapons, to stay away from that incident location, a no contact with the victim in this case, and the completion of an anger management course. The victim in this case is Jeffrey Brown. If we could sign for him in accordance with Marcy's law, that'd be greatly appreciated. Our office was able to get in contact with him, and I do believe that he confirmed the events in the warrant. Nothing further to add from the state at this time, Your Honor.
He stated he didn't want any further contact.
That is correct.
All right.
Yes, Your Honor, we'd ask for the signature bond. This is her first offense. She works at Lockheed. She works as an aeronautics trimmer. She was in the process of moving out. She had the police escort to help her move out, but things were hidden. And that's when she had asked to get the additional items back that were hidden during the move. She does have since she was moving out, she has another address and her kids are now with her sister. So we'd ask for the signature bond in this case.
Okay.
And I'm sorry about my dog.
That's okay.
Don't hold her in contempt.
$3,000 signature bond through pretrial, $2,000 on the battery, $1,000 on the cruelty. Stay away from 4465 Grenada Drive. No further contact with the victim, Jeffrey Brown. And no drugs, alcohol, weapons, guns, or unprescribed medication while on bond.
And Your Honor, the victim is present, so if we could sound for him just in case he'd like to be heard, that'd be greatly appreciated.
Oh, Mr. Brown, Jeffrey Brown.
Yes, Your Honor. How are you doing?
Good. I didn't see you on there. Do you wish to address the court today? Yes or no?
No, Your Honor.
Okay. All right. That's the order of the court. 3,000 signature bond through pretrial. Oh, and she'll be level 1. That should be it.
Position 1, Mr. Booker.
(24 CR 008238H), Christopher Booker, charge of 1 count of theft by shoplifting, pretrial.
15. Got an open burglary in the first degree, possession of tools, theft of lost and mislaid property, possession of marijuana less than an ounce. That's 24 PI 007085. 2020 disorderly conduct conviction. 2020 battery, simple battery dismissed. That's all.
Okay.
Good morning, Your Honor. Your Honor, the facts of this case are Mr. Booker was seen by Walmart security team on December 19, 2024 at the Walmart at 844 Cleveland Avenue in East Point here in Fulton County, where he was seen loading his cart with multiple items, including a 115-piece T-shank jigsaw blade, 3 Dove men deodorants, 2 Huggies, packs of wipes, 1 Johnson bedtime wash, 1 Hart tool combo kit, and 1 Hart combo kit. Your Honor, Mr. Booker then went to the self-checkout where he paid for one Huggies pack of wipes, and then he loaded the other items into bags and left out of the Walmart. As he was leaving the Walmart, one of the checkers at the Walmart asked to see his receipt. He refused and he walked out. The officer on scene immediately approached Mr. Booker and asked Mr. Booker to come back into the Walmart with him. Mr. Booker refused to do that. So that officer did place him under arrest and took him back into the Walmart, where that officer did see Mr. Booker on the surveillance camera taking those items and not paying for them. Your Honor, the state is requesting a $2,000 surety bond. Anti-theft course, stay away from all Walmarts, and no alcohol, drugs, or weapons. That's all from the state, Your Honor.
Okay. PD Melnick, is this yours?
Yes. I'm sorry. Yes, Your Honor. Mr. Booker is my client. He is from Atlanta. He works on trade shows. That's where he's employed. So he is between. We are asking for $1,500 signature bond. His current bond now is $1,500 bond, which was set when the arrest warrant was issued, but we're asking for it as a signature bond.
Mhm. Well, considering the history and a few other factors, I'm going to order the $2,000 surety bond. With that surety bond, he's to stay away from all Walmarts in Fulton County while he's on bond. And no drugs, alcohol, unprescribed medication, weapons, or guns while on bond. And I think that'll be it.
Thank you, Your Honor.
Mm-hmm.
Number 3, Chappelle. Miss McLeod, can you call the courtroom?
This is 24 CR 008253Y. Jermaine Chappelle, charged at 6 counts. 2 counts of battery, family violence, and 4 counts of cruelty to children in the 3rd degree pretrial.
25. 2020 FTA, 2019 FTA, 2018 battery DV conviction, 2012 battery conviction, 2009 a freight conviction. That's it.
All right, state.
Your Honor, this took place on December 16th, 2024 at 1147 Hubbard Street in Southwest Atlanta, Georgia. Your Honor, when police arrived to the scene as a home, police saw Mr. Chappelle along with another gentleman, Mr. Redding, his father, in a physical fight. They were able to break up that physical fight and able to speak to Mr. Redding Jr., who is Mr. Chappelle's brother. And once they started speaking to Mr. Chappelle, they saw that, or Mr. Redding Jr. say that Mr. Chappelle started arguing with his mother and the mother of his child. They had been drinking, and Mr. Chappelle became irate. At some point in time, that verbal altercation then turned into a physical altercation with Mr. Redding Jr., Your Honor. And then once Mr. Redding Jr. and Mr. Chappelle started their physical fight, Mr. Redding Sr., the father of both, tried to de-escalate the situation and pull them apart. But unfortunately, Mr. Chappelle started fighting his father, Mr. Redding Sr. When officers arrived, they saw visible marks on both Mr. Redding Jr. and Mr. Redding Sr. Your Honor, there were, I believe, 4 children who witnessed this physical fight. that were in the home. The state is asking for a $2,000 surety bond on count one, a $2,000 surety bond on count two, $500 surety bond for each of the four cruelty children, cruelty of children in the third degree, a family violence intervention program, of course, stay away from 1147 Hubbard Street, Southwest Atlanta, Georgia. Your Honor, our office did try to reach Mr. Redding Sr. and Mr. Redding Jr. We have not been able to reach either. I do see Miss Jessica Teller on. Your Honor, she was at the scene of the incident at some point in time, and was involved with this incident. But again, Your Honor, she's not a named victim. So we are asking for the that bond recommendation and ask that you grant that.
Who are the victims?
The victims, the children victims, Your Honor, is that what you're
The
asking?
adult.
The adult victims are Keon Redding Sr. and Keon Redding Jr. The brother of Mr. Chappelle, who lives at the residence with him at 1147 Hubbard Street Southwest, and Keon Redding Sr. is the father of Mr. Chappelle.
PD Melnick?
Yes, Your Honor. First of all, I think we have a Riverside issue because my client was arrested on the 16th and he has been in custody, and this is the first time he has seen the court, and today was the only first time he's had his charges given to him. Secondly, he and his brother were in an altercation. And that both of them ended up going to the hospital. It was not just him, but I think and his father did try to break it away. And I did explain to him, I said, you guys are a little too old to be fighting as brothers. But I think it was a one-time incident that got into it. But I do think we have a Riverside issue. So we are asking for signature bonds on the cases.
Ms. Lewis? Does it show him being booked in? I see number J's in jail too from the 21st.
He was his booking screen.
But he looks taken into custody. It says the 16th on the booking screen.
Is that on something else?
No, Your Honor, it was on this case.
I'm seeing he's booked in on the December 20th, Your Honor.
No. I'm also seeing he was arrested. It says arrested on December the 16th, 2024 at 8:30 p.m.
Yes. And if you see arrested date at 8:30.
That's the arrest date. And then he was booked in on December the 20th
He was
at
in Grady custody.
11:34 p.m. Did he go to another precinct before he got to Fulton County?
He was in the hospital for a bit, but he's been in custody. He was not released, and this is the first time he's been in custody with
When did he leave Grady?
Yesterday. He left Grady's on yesterday.
Oh, then that's not Riverside if he was in Grady
but he
custody.
was in Grady custody. He was in Grady custody and free to leave.
So
he got arrested, then he went to Grady?
Yes.
And he's been in Grady ever since. Yeah,
correct, but
okay.
Not Riverside.
So, Your Honor, I believe that's not the fault of the state. I mean, he was in custody.
he was not free to leave.
I mean, he was not in custody. He wasn't booked in until December 20th, Your Honor. December 16th is when this incident did occur. However, he was in Grady Hospital.
Not free to leave, which makes him in custody.
But was he booked and arrested on the 16th? If they just took him to Grady first, but they didn't book him in until the 20th?
He was arrested in custody under the law. But regardless, the two brothers that were fighting, the only reason the kids were in the car because they were the pepper spray the officers used on him.
I mean, but there was nothing that the state could do. Like if he had injuries and he needed to be seen by the hospital, there's nothing. He wasn't going to be able to be seen in the hospital from the 16th until the 20th.
I mean, I hear what you're saying. I'm just saying though that he was not free to leave because he was in the lockdown section of Grady, which makes him in custody. He wasn't on the floor free to go, which which falls in definition. But regardless, if let's look at the facts of the case, it's two brothers that are getting into a fight. This is not a threat to outside of this. It's
his brother and his father.
right.
His
right.
brother who he lives with, and his father who I don't know if lives at the residence, but his father who is there.
Right. And so
we're asking, Your Honor, you've heard what we're asking for.
Yeah.
Well, if it's a Riverside issue, it's different, but I don't, what do you all have as his booking date? What's
I
on the
have
booking
this booking
screen?
that December 20th as booking when I look at the jail screen.
Right, and that's what we go by as the jail screen.
But the law is custodial. But like just trying to split the baby going on this, because it is Riverside, just looking at the facts, this is like a one-time incident with these two.
No, I'm not looking at the facts per se.
Oh, yeah.
Or Ayala somewhat, but courtroom 2.
Yes, ma'am.
What do you have as the booking date?
Got booked in on the 20th of yesterday at 11:34 p.m., but he also was in custody December the 16th, 8:30 p.m. That's when he was arrested.
Yeah.
Right.
But Atlanta Police Department.
And Your Honor, it has to be, it's not the fault of the state. It has to be attributable to the
I
state.
can't hear. Yeah, the defendant should be quiet. Okay, go ahead, Deputy.
Your Honor, it has to be attributable to the state. It has to be the fault of the state, the delay of the state, which is not. He was in the hospital getting treatment for whatever reasons he needed to get treatment for. And he was booked in on the 20th. There's no way that we could have even seen him from the 16th until the 20th. This is the earliest that we could have seen him. So there is no, it's not the fault of the state that he was not seen. So we're saying that this is not a Riverside issue, number one, but then number two, there is no other time that he could have even been seen. Your Honor, and not only that, and I hear Ms. Melnick saying that, this is a one-time off issue, but he does have a previous battery family violence. This is the young gentleman that we thought that could be a felony. So not only does he have, a previous battery family violence, Your Honor, he had issues, or he had altercations with two of his family members, one of which he could go back to that same home. So we're asking, Your Honor, for the bond recommendation that we previously recommended.
Right, Your Honor. And going under the law, it does not say officially booked. It says in custodial. So in just looking at this, he's not going, this is not a threat to society. He going back, I mean, when you're looking at the factors, because I'm trying to mitigate it, as well as bringing it up, it does not say, the Riverside Promise does not say book. It says when in custody. What we typically go by is not necessarily what the law is saying. Because you heard
go ahead.
I mean, you heard the deputy, he was taken in. Jail would not take him. They were trying to book him in. He is in possession of the state. He is in possession of the state.
But for his own safety being at the hospital.
Okay, then why couldn't he leave to go? Why couldn't he go?
Maybe he still needs to be in the hospital.
You see, you don't know. And that's the whole thing. The knowledge of the officers is imputed on you by law. So
absolutely not. I mean, 4 days in the hospital. Clearly he needed to be there. I'm sure Grady just doesn't want to have people in their hospital just sitting around. Like, that's more money on the state. Like, absolutely.
You're speculating at this point. And
well,
this gets to my point that if he's in the hospital for 4 days, is he really the victim? If he's in the hospital for 4 days, is he really the victim of this?
You're speculating.
Hold on a second. Hold on a second. Let's pause for a second. Let me find.
No. They muted me.
All right, I'm going to rule that it's not Riverside. Booking dates date he came to the jail. And I'm going to go with the and rule on it with the $6,000 surety. 2,000 on each of the batteries, 500 on each of the cruelties. So that would be 600 surety. Stay away from 1147 Hubbard Street. No further contact with the victims, Keon Redding, senior and junior. No further contact with the minor children. No drugs, alcohol, weapons, or guns while on bond. And that would be it.
That's 6,000 surety.
6,000. All right. Next.
Number 12, Johnson.
I'm so sorry, back on the last one, I'm so sorry, can we have that reduced to writing that we denied the Riverside issue?
We can put it in there. Put it in the order you're saying? Well, if he
Yes,
doesn't have a
please.
signature bond, I think it would be clear, but
No, but the fact that I did, if I decide to do an immediate repeal, just so I can have it in writing that is there.
well, the day that he arrived at the jail was not the 16th, and then they took him from the jail to go to Grady's is a little different than
Right.
going straight to Grady and then being booked in on the 20th at the jail. But
Right.
if you want, Katrina, if you want to put that on the order, it doesn't matter to me.
That the court found that he was arrested on the 16th, but booked in on the 20th.
Put what in order?
No, I'm not saying that because I didn't say that. I didn't
Oh,
say I
sorry.
found he was arrested on the 16th. I just said it is not a Riverside issue because he was not booked into the Fulton County Jail until the 20th. That's the way it should be stated, Katrina.
Does the court have a finding of when he was taken into custody?
No, because I don't need to.
Okay.
I'm going by the jail booking screen of the 20th.
Okay, and I'll show that the a warrant for arrest was formed the 16th.
Well, that's factual. I mean, there's no debate about that.
I just have to have the record clear. I'm sorry.
I'm trying to have the order clear. What are y'all saying?
In the order, it should say that the court found that there is no Riverside issue because the defendant was booked into the jail on the 20th. That's all I'm gonna say. I'm not gonna rule on anything else but that.
All right. Thank you.
We're on position 12.
Yes, ma'am.
24 CR 008246Y, Edward Johnson, charge of 1 count of theft by shoplifting and a 2nd count of simple battery.
18. Got an open case out of New Mexico for possession of a controlled substance and burglary. 2024 FTA probation, 2024 battery shoplifting, 2022 FTA, 2021 simple assault, simple affray, injury to property conviction. 2020 assault on female conviction, 2017 assault conviction FTA, 2018 FTA, 2018 disorderly conduct conviction, 2015 FTA shoplifting conviction. And he's homeless.
Your Honor, very straightforward facts is that on December 22nd, the defendant grabbed a chainsaw valued at $250 and walked out of the store without paying for it. Also on his way out, not to be outdone, the defendant punched or struck the victim, in this case, Stephanie Rodriguez, as he fled the location with the stolen property. Our office was able to get in contact with Ms. Rodriguez. She stated that she'd like for the defendant to remain in jail. She stated that she understands that he is entitled to a bond. However, she wants no contact. She still works at that location being the Home Depot, located at 650 Ponce de Leon Avenue, Atlanta, Georgia, here in Fulton County, Georgia. And she advised that she will be on Zoom. However, she does not wish to give a statement. But if we could sound for her in accordance with Marcy's thought, that'd be greatly appreciated. Your Honor, we've heard about his 18 arrest. In addition to that, we've heard about the failure to appears as well as his violent propensities. And so for that reason, we think that the bond is currently set as more than reasonable. The current bond is as set. It is $600 on the theft by shoplifting and $1,000 on the simple battery. The remaining conditions that we'd like to be placed on the bond is for him to have no alcohol, drugs, or weapons, for him to stay away from that Home Depot, and for him to have no contact with the victim. There's nothing further to add at this time from the state, Your Honor.
All right. PD Melnick?
Yes, Your Honor. My client has lived in Atlanta for a while. He is looking for employment. His employment has been brief. He does have a mental health diagnosis, and we would ask for a signature bond. Otherwise, it'd be tantamount to no bond.
I'm going to leave the bond at 1,600. 600 on theft by shoplifting, 1,000 on the simple battery. Stay away from the Home Depot at 650 Ponce. No further contact with the victim, Stephanie Rodriguez. No drugs, alcohol, weapons, unprescribed medication, guns, while on bond.
And Your Honor, if we could sound for her, I see she's on just in case she changed her mind.
Yes, Miss Rodriguez,
Yes.
do you wish to address the court today, yes or no?
Yes, ma'am.
You have to turn on your camera and you have to be sworn in first. Raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Do you have any fear of Mr. Johnson?
Yes, ma'am, I do.
Do you want to have any further contact with Mr. Johnson?
No, ma'am.
Okay. And that's what I've ordered. He's to have no further contact with you and to stay away from the Home Depot. If you see him come back, then you need to call the police, okay?
Okay.
All right.
I wanted to ask if maybe we could raise the bond just because, like, he was super violent with me and I just feel like 1,000 isn't enough for what he did.
It's actually 1,600, 1,000 on the battery, 600 on the theft. Although he has history and a diagnosis, I'm not going to raise the bond. I'm going to leave it at the 1,600. Okay. This is a bond hearing. This is not his trial. There'll be another opportunity for that. Stay in touch with the Solicitor General's office and the victim witness advocate so that you can get information on the case. Okay.
Okay.
All right. Thank you.
Position number 19, Mr. Wilson.
This is 24 CR 008243A, Charles Wilson, charged with 1 count of battery, pretrial.
Let's see, we got 28. I got you guys an open case out of the cab, battery DV, simple battery DV, disorderly conduct. Another open case out of the cab, simple battery, cruise in the third. Battery DV, simple battery DV, disorderly conduct. Hold on. I got another open case, simple battery DV, disorderly conduct. They got different case numbers. Got an open case out of Doherty County, simple battery DV, on probation out of Doherty County for aggravated stalking. 2023 battery DV conviction, 2020 probation, 2020 battery trespass conviction, 2017 FTA out of Florida, 2013 simple battery DV. That's it.
State.
Yes, good afternoon, Judge Mancy.
Afternoon.
On September 6, 2024, Mr. Baron Woods, Baron spelled Barron, Woods, common spelling, reported to the Atlanta police that he had been involved in a physical dispute at his job with one of his ex-employees, Mr. Charles Wilson, the defendant. Mr. Woods told officers that he's the manager at Pizza Hut at 202 Bolton Road, and the defendant became upset about him cutting his hours, and he let officers know that the defendant approached him very aggressively, and then he punched him several times. The officer noted in the warrant that there was a considerable cut above his eye that required him to get 4 stitches as a result of this incident. Your Honor, our office was able to speak to Mr. Woods. He let us know that he felt that as though that the defendant should not get a bond. However, our office let him know that he's entitled to a bond under the Georgia law. He did confirm the events listed in the warrant. He also let us know that the defendant stays in the area, and he now has to be cautious when he's going to the store. He just wants to be aware of his belongings for himself and his girlfriend. He let us know that he does not want any contact with him, and that he also has pictures of the injuries, Your Honor. Giving his history and the events listed in the warrant, the state's recommendation is a $10,000 surety bond. We're asking for him to complete 6 hours of anger management, to have no further contact with Mr. Baron Woods. We're also asking for him to stay away from the Pizza Hut located at 202 Bolton Road in Fulton County, as well as no alcohol, drugs, or weapons while out on bond. I would like to sound for Mr. Woods in case he would like to speak, Your Honor.
All right, Mr. Woods, Baron Woods, are you on the call?
Hello, can you hear me?
Where are you? Yeah, I need to see you though.
Okay, I don't know if the connection is any good. I do apologize, but hello, my name is Baron.
I cannot talk to you until I can see you. All right, are you driving?
I'm overseas. And I didn't have a good connection, so I'm trying to work on it today.
I cannot hear you. I just asked if you were driving, yes or no.
I'm overseas.
You have a terrible connection. I can't understand what you're saying. Are you driving? It looks like you're driving. And if you are driving, you need to pull over, or else we're going to cut you off the Zoom. You cannot be driving. What?
Judge, I think he's driving. Do we just want to take him out the Zoom?
Yeah, take them off. All right. Thank you. All right. Who's the PD on this case?
That would be myself, Your Honor.
All right, go ahead.
Thank you. So Mr. Wilson is a lifelong resident of Georgia. He's expressed to me that he has a brother, a sister, as well as a niece on the way, all living in Georgia. He has significant family presence here in Georgia. My understanding is that he no longer works for that position that Mr. Woods was employed at. He's expressed to me that he works at a warehouse production facility during the day and an Arby's at night. Considering that he does not work in that area anymore, I don't think there are significant issues with contact while the case is ongoing. We would just ask that Your Honor be willing to consider a $3,000 bond in this case.
Considering the number of open simple battery and assault cases, and I lost count, I would order a $6,000 surety bond and no further contact with Mr. Barron Woods. Stay away from that Pizza Hut on Bolton Road. No drugs, alcohol, weapons, unprescribed medication, or guns while on bond.
Like that.
And
Reiterate and let people know that they need to keep muted and keep their phone off if they're not being addressed.
yeah, we're going to just put you off the Zoom link. If I get any more outbursts, I'm getting too many today for some reason, or people that can't understand how to keep their phones on mute. So if you don't keep it on mute, there's an outburst, we'll just put you out of the Zoom. And so that's all I'm going to order is to stay away and no further contact. And $6,000 surety.
Understood. Thank you, Your Honor.
All right, thank you.
Good afternoon, Judge. I have position number 4, Ms. Eccles, and can you please read their rights?
All right. Excuse me. And so for those at ACDC, you have constitutional rights, including the right to representation or counsel, which you should have spoken to them by now. And you also have a right to remain silent. And remember that anything that you state about the facts, circumstances, or the occurrences can and will be held against you. The state is here and they're listening, so follow the lead of your attorney, okay? All right. This case is 24 CR 008230Y. Antonika Eccles, charged with 1 count of battery and 2 counts of cruelty to children in the 3rd degree.
It's the third
Your
arrest.
trial?
2021 shoplifting dismissed. 2019 shoplifting. Level 1.
All right. State?
Yes, Your Honor. So this incident took place on July 1st of this year. It took place at 1620 Hollywood Road Northwest. This is the Dwell at the View Apartments complex. Our victim, Antonisha C., that's spelled ANTONISHC is spelled SEAY. Miss Antonisha and her 2 minor children, both with the initials SC. The defendant went to the victim's home unannounced and knocked on her door. And when the victim opened her door, the defendant then struck her multiple times, causing cuts and scratches on her face. The incident was captured on video, and the defendant actually posted it on social media, Your Honor. Our office was able to speak to Ms. Antonisha, and she let us know that the defendant was dating her child's father. She told us that her children's father texted the defendant and told her that he could no longer see her because the victim was keeping their children away, Your Honor. She also let us know that after the message was sent to the defendant, the defendant then began messaging the victim on social media and cursing her out, Your Honor. Miss Antonisha's children are both 9 years old and 2 years old when this incident happened. So given this, the state is asking for a $1,000 surety bond on the battery charge and a $500 surety bond on each count of the cruelty to children to stay away from Miss C and her children, or any members of her family, as well as the incident location, which is 1620 Hollywood Road, the Dwell apartment complex, Your Honor, as well as no alcohol, drugs, or weapons while out on bond. And I would like to sound for Miss Antonisha if she would like to speak.
Yes, I'm available.
Can you stop walking?
I'm sorry.
All right, raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. Are you in fear of Miss Antonika Eccles?
No.
Okay, do you want to have any further contact with her?
Nope.
Okay. Do you all live in the same complex?
No.
Oh,
I
okay.
actually live in a gated community. You have to be buzzed into my gate to get in my gate.
Okay. So is it the 1620 Hollywood Road or no?
Yes.
Okay, so that is your address, but it's gated.
Mm-hmm.
And so is that not where the incident occurred?
Yes, that's where it's occurred.
All right. But she can't get in, or did she get in that day or?
Yes. No, I didn't let her in that day. I still don't know how she got in that day. I live in a gated community. You have to be buzzed in by the person you're coming to visit to get in. So that means she snuck in behind somebody or just.
That's
I don't
usually what
know.
happens.
Yeah.
Usually they either drive in, walk in, or do whatever.
Yeah, and I never
so-
gave her my address. The story I was told on how she got my address was she was supposed to work a government job, and she used her job to get my address, and she posted it online.
Wow. All right. I'm going to make sure I order no more social media posts about this case or about you.
Thank you.
All right. So any cross-examination by state or by the PD?
Your Honor.
Okay. All right. So you can mute yourself. Miss, is it say or C?
It's C.
C. Okay. All right. Thanks for getting on, and let me hear from the other side, and then I'll make a ruling. Okay. All right.
Yes, yes, Your Honor. This incident did occur back July 1st. Today is obviously not the day for a trial, but wait. Sorry. But we are but there haven't been any other indications from the complaining witness or any police reports of anything. So this is any type of potential cooling off period has happened, and we would ask for a signature bond on her case.
All right. Does Miss Eccles work or anything?
Yes, Your Honor. She's going to be working at Chick-fil-A at the airport. She does her job.
And hopefully this is over. Because I do have some concerns about the situation.
Your Honor, the state has some concerns too. Just as me reciting the facts and we're going over what's going on, it just looks as though the defendant is laughing or smirking about the situation. So I just want to make sure that you reiterate to her that this is a serious matter, that she's not to have any contact or say anything. This is not a laughing matter that the victim has gone through. I just want to make that very clear.
Yeah, I disagree. This is a very serious matter. I think I disagree with that statement. I think she's just been shaking her head. This is an older thing. The complaining witness said that there was no indication of immediate threats. We're asking for a signature bond.
I'm not for sure. The complaining witness says she didn't want to have any contact. She may not be in fear now. And again, with her history, it's her third, but it looks like one or two of the charges were dismissed for shoplifting. I don't see, and state tell me if we know otherwise, there's no previous violence in her history.
No, there's no other previous violence in her history. It's just the fact that she came to the apartment complex that we heard is gated, you know, to fight this woman. And it appeared to me during me reciting the facts that she was smiling and smirking at the facts. I just wanted to be clear that this is a serious matter and that she's not to have any contact and what all that encompasses.
And I have the highest respect for Ms. Bickerstaff. I've worked with her before, but we're on Zoom. So I do disagree with her assessment of this in this case. It's not disrespectful. It's just, I disagree with assessment.
Yeah. Well, I've sometimes take judicial notice of the attitude or the disposition or demeanor rather of the defendants. And I have noted it at times when it's glaring that they're kind of mocking the situation. So hopefully that's not the case for this defendant, even though it's been some months. And what I'm going to do is order a $4,000 signature bond through pretrial. And that will be $3,000 on the battery, $500 on each of
Excuse me, Judge. I'm sorry. She still to this day currently have a screenshot picture of me and her fight as her profile picture on Instagram. So it's old, but yes, mocking is still going on.
Although the mocking is still going on, I guess my biggest issue is, will she come back to court? Is she connected? And I'm going to give her some instructions if this bond, while she's on bond, and it did happen in July. So I'm going to order that she take that down. But I'm trying to decide now whether I'm going to give her a signature bond through pretrial or a surety bond. I mean, she qualifies for a signature bond, honestly. And I know, again, this is not the trial. This is not the time to punish her for the allegations, although I'm going to order some conditions on bond. And if she violates those while she's out on bond, she'll be rearrested, brought back to the Fulton County Jail. And so I'm not going to base the bond on the allegations or some of the facts that have happened, you know, months and months ago. But I'm going to say to you, Ms. Eccles, that I hope that this is over and that you will comply with your bond conditions. And if you don't, you'll be rearrested. I'm going to order a $4,000 signature bond through pretrial. The $3,000 is on the battery, $500 on each of the cruelties. And I want you to take that picture down off of your social media. You're going to take all references off of your social media to Miss C. There's to be no pictures of her, no comments, no talking on Instagram, social media, Facebook, and any other pages that you have. And so you need to let your friends and family and relatives know that they're not supposed to talk about it either, because they can get you in trouble if they post about it or have pictures about it. So if you have a picture of this incident or this fight or a video or any other talking about it on your pages, you need to take it down immediately. Understand? And you're not to post any new information about the victim here, Antonisha C., or any of her children, relatives, family. You're not talk about any of them. You're not talk about the case at all. Can you do that? Okay. And you'd have no guns, weapons, drugs, alcohol, or anything while on bond. You're to stay 200 yards away from Miss C. And that's 2 football fields. So if you go somewhere and you see her or she sees you or whatever, you need to go the other way, because you can be arrested for being closer to her than 2 football fields. You're to not text her, not text anybody about her, any of her family, friends, or relatives. You're not to go around her job, and you're not to go to this incident location, 1620 Hollywood Road. If you have a job that you're abusing or using in order to gain entry, you need to stop, because if you do that again, she's going to call us and you'll be rearrested, okay? I'm being very, very clear about it, so there's no misunderstanding. You are not to go to that complex, the Dwell apartment complex. You shouldn't even be there. You don't live there, right? Okay, so you don't need to be there at all. Whether you're looking for the father of your children, if this is his new girlfriend, don't care about any of that. You're not to be at that complex. So if you have any other questions, talk to your attorney about it so that you don't wind up back in jail. All right, thank you. And Miss C, keep in touch with the victim witness
What
advocates
level
if
is
you have
this?
any questions or issues.
What level is this?
Level 2.
Level 2 now? Okay.
Yes, make your level 2.
This
Next.
is position number 13, Jones.
I am so sorry. What position was this? I just can't hear her.
13.
Position 13, Jones.
Okay, I'm sorry.
24 CR 008247Y. Shakita Jones, charged with 1 count of criminal trespass. Pre-trial.
38. Got an open case out of Doraville, criminal damage to property. Open case out of Atlanta for trespass. Got another open Doraville shoplifting. Open case out of South Carolina for battery, Columbia. Open case out of Richland County for public disorderly. That's what it says. 2024 trespass, 2024 shoplifting. 2019 theft of lost mislaid property, trespass conviction. That's all.
We got a brief facts of the case is that on December 20th, 2024, the officers responded to a criminal trespass call, which was a 911 call located at 1559 Alma Street, Southwest Atlanta, Georgia, and Fulton County, Georgia. Dispatch advised that a passerby had observed an unknown black male and black female exiting out of a vacant location. Upon arrival, officers observed a shattered front window with damaged blinds and the metal front screen door completely open. The officer observed the front door as being slightly cracked open with a damaged door frame. The officer discovered the defendant sleeping on the floor in one of the bedrooms. The defendant advised that she had permission to be on the property by the owner when she entered the premises. However, she was not able to provide proof of residency as well as permission from the property owner to be on the property. The officer was able to make contact with the property management of Elite Realty Group, and Mr. Calvin Gleaton, Gleaton, was authorized by the property owner, that property owner being the victim in this case, or the listed victim in this case, Dong Lam Bam Lee, DUONG -LAM BAM, last name Lee, LE. Mr. Gleaton advised that he did not give anyone permission to enter the residence, including the defendant, Ms. Jones. Mr. Gleaton advised that he would like to, in fact, press charges. Your Honor, I think that we heard of the 38 arrests at this point and the 2 arrests from this year. At this time, the state takes the position that a $500 surety bond is more than reasonable in the matter. And given the facts of the case, we would request no alcohol, drugs, or weapons, a stay away from the incident location, and a no contact with Mr. Lee. And if we could sign for Mr. Lee in accordance with Marcy's law, that'd be greatly appreciated, but there's nothing further to add from the state at this time.
All right, Mr. Lee. I don't think I see him on. All right, PD Geddes.
Yes, thank you, Your Honor. Ms. Jones is 37. She has a brother and sister and some other family members who live in Georgia. Unfortunately, she does not have a stable housing situation. She has had difficulty maintaining employment as well as a stable living situation for the past several years. She has expressed to me that she is in communications with some friends of hers as far as getting a long-term, more stable residence, but as you heard from the criminal history, it seems like the majority of her offenses are related to poverty and housing in some way. Your Honor, based on her housing situation and lack of finances, we would ask that you consider a UJR. I suspect that anything otherwise, she would likely be unable to get out of custody.
Right now, there's a 500 surety bond there. I would like to just keep it at that. Stay away from this 1559 Alma Street Southwest. Do not go to, is it a complex of some sort? Or just a location?
It appears to be a complex that is owned by, one moment, that is owned by Elite Realty Group.
Right. So stay away from that whole complex there. I don't know if we have the name, but I assume she's aware of this complex, to not go back to that complex at all, since she does not live there. Maybe you can have your social workers talk to her, see her, if they can help her with some housing. So to stay away from that property, no further contact with any people there. I guess there are no victims here. No drugs, alcohol, weapons, guns, or unprescribed medication while on bond. 500 surety.
My apologies, correction, Your Honor. It's a house, and I guess there must be separate ownership inside the house.
Oh, okay. So it's a house. Okay. But just make sure you stay away from that property, period.
Can that be clarified for the order? Can I know what the property address is? Nobody said anything.
Yes, it's 1559 Alma Street Southwest, Atlanta.
Okay.
Alma spelled A-M-A.
All right. That should be it.
Position 17 and 18, the Stedman brothers.
You said 18?
17 and 18, the two brothers. Stedman.
Oh, same. Okay.
So I only had one on the pool sheet.
Huh?
We had one of them on the pool sheet.
Can't hear you.
I said I only had one of them on the pool sheet. I'm about to pull the other history now though.
Oh, okay. And they're both before us. 24 CR 008255Y. Paris Stedman, charged of one count of willful obstruction of a law enforcement officer. Second case is 24 CR 008242G. Robert Maurice Stedman, same charge, willful obstruction.
Your Honor, the case with Paris Stedman should have also had a pedestrian and walkway charge attached.
Judge, that charge was added after the calendar was produced. There is a second charge on Mr. Paris Stedman on position number 17. So it's two charges instead of one.
All right, and the second is pedestrian in the roadway.
Pedestrian must walk on a sidewalk if provided.
Okay.
We shown another one in booking. It's called equipment required on a bicycle.
Yes, that one was NOD.
Okay, thank you.
Mm-hmm.
Okay.
And
all right.
I'm sorry, go ahead, Your Honor.
No, you go ahead.
I can give you what I saw for criminal history wise.
I got Robert.
Okay.
I don't have Paris though. And he got 30 cycles, so I would have to break it down. So let me give Robert and you give
Paris. Okay.
Okay.
Yeah.
All right.
Robert, I saw 36 on probation, possession of cocaine, 24 SC 000696. 2023 probation, 2023 possession of a Schedule 1 conviction. 2022, 2023 probation, 2016 FTA probation. 2012 use of a firearm during the commission, possession of a firearm by convicted felon conviction, and a drug conviction from 2011.
Okay.
Okay. And then for Paris Stedman, I'm showing 32 cycles. Most recent, given false name in 2016, a possession of cocaine, conviction in 2016 and 2019, criminal attempt to commit felony in 2013. The other convictions are older convictions, Your Honor.
Okay.
On yesterday, December 20th of 2024, officers were conducting a direct patrol near 121 Cleveland Avenue. This is the mobile gas station. The officer noticed a black male on a blue bike, which did not have a blue light attached to it. The defendant continued to ride that bike on the sidewalk, which is a city ordinance violation, Your Honor. Officers initiated the blue lights and the defendant did not stop. He actually went into the roadway, escaping or not stopping for officers. He eventually dropped his bike behind a vacant home and continued to travel on foot. Officers were able to detain the defendant, in which he resisted arrest. While he was being detained, his brother, Robert Stedman, approached officers and told the officer to get your MF and hands off my brother. He didn't do anything. And so that is the reason for his willful obstruction charge. In regards to Paris Stedman, Your Honor, the state is asking for count two, given his history, a $100, not count two, but for the pedestrian count, a $100 surety bond, and then for the willful obstruction, a $500 surety bond, as well as no alcohol, drugs, or weapons while out on bond. And then for his brother, Mr. Robert Stedman, the state is asking for a signature bond through the jail for that willful obstruction charge.
And who's representing whom?
Your Honor, I am representing Mr. Paris Stedman. I believe Ms. McLeod may have Robert Stedman.
Okay.
Okay. Would you like me to proceed first?
You can.
Okay. Mr. Stedman is a lifelong resident of Georgia. He is 46 years old. He has a significant family presence in Georgia. He's told me his mother, his father, he has aunts, cousins. He has 3 children who all live in Georgia as well. He has been self-employed for the past 5 years, doing a professional pressure washing business. He cleans buildings, cars, etc., things along those lines. He does have his GED. We would just ask that Your Honor consider giving him a signature bond in this case.
And which one? Raise your hand, Paris. Okay. Although the charge may not be as serious as some of the others, I'm concerned about the cycles. Although I think was the most recent 2019, or was there one before then? I mean, most recent was 2019. Was there anything after that?
I did not have it noted, but I can do a double check for you, Your Honor. Just see. See. 2019. I'm seeing. There's an arrest for a failure to appear for this year.
Which one are we talking about?
Paris.
Mr. Paris.
Um,
I'm seeing a 2021 given false name conviction.
Paris last arrest was 2023, possession of a Schedule 1 or 2, possession of drug-related objects, DUI, suspended license, window tint. Yeah. I don't know what the dispositions were. I could look it up real quick. Hold on.
I did want to jump in briefly on the FTA, Your Honor. I was aware of that, was able to do a bit of research. It looks like that case was dismissed and then re-indicted at one point. I think the FTA may have been related to the confusion surrounding that.
Okay.
The 2023 is open out of leverage. Judicial hold, it says.
All right, I will order the state's recommended bond, a $600 surety bond for Paris. No drugs, alcohol, weapons, guns, or unprescribed medication while on bond. And
The breakdown, please.
300 on each. I guess that'll be it. There was no stay away provision, I guess.
No, yeah, there's no stay away for this case.
Okay. All right. Next case I have with Miss McLeod, which is on Robert Stedman.
Good afternoon, Your Honor.
Good afternoon. And there's been a recommendation of a $500 SOB jail. Any objections?
No objection, Your Honor.
All right, and I'll order that $500 SOB jail. However, Mr. Robert Stedman, you're to stay away from that location. No drugs, alcohol, weapons, or guns while on bond. All right.
You read the convenience store?
What's the
I'm sorry.
What location? I'm not sure what location.
That's I'm lost too.
It happened at 121 Cleveland Avenue, in that area, the Cleveland Avenue area.
My understanding is that my client lives on Cleveland Avenue.
Oh, how close to that location?
Well, his actual address is 104 Cleveland Avenue.
This
Can he
is,
speak to say?
I'm
what is-
sorry,
Go ahead. That one was
21.
So it sounds like they could be distant. Mr. Stedman or Robert Stedman, are you able to stay away from that location? There's no reason for you to be there. Is that correct? Okay. All right. Stay away from that location while you're on bond.
And Robert Stedman bond was a signature bond through what? The jail?
To the jail.
Okay.
Yes.
Your Honor, if I could weigh in on that.
Yes, please.
Under SB 63, because it's willful obstruction, I don't believe we can give a signature bond through the jail. It's one of the charges that they added that is prohibited.
All right. I will order.
Just level 1 it. It's
All right.
obstruction.
I will order the 500. Thank you, Deputy Falk. I will order the $500 signature bond through pretrial level 1. All right. Anything else?
Thank you, Your Honor. No, that would be all.
All right. You don't have any more cases?
No, Your Honor, I do not.
All right. Well, as they say, start going somewhere and enjoying your holiday.
I'm just going to quietly enjoy the holiday at home.
Quietly enjoy it at home. Okay. All right. Well, get you some rest.
Thank you, Your Honor.
All right. Take care.
I'm sorry to interrupt, Judge.
You did.
I just want
Yes.
clarification because y'all was going back and forth on position 18. Mr. Roberts is a $500 through pretrial level 1.
Yes.
No alcohol, no drugs, no weapons, and that's the only condition, or there's still a stay away.
Well, we are going to do the stay away. He says he can stay away from that location. He lives down the street from it. So yes.
This is 121 Cleveland Avenue, am I correct?
That's correct.
And that's just for Mr. Stedman, and for 17, there's no stay away.
Okay, my client lives at 104.
I thought I said to stay away on the other one as well for Paris. Did I not?
No.
Oh, well, for Paris to stay away as well.
But
Because I don't think either one of them live there. Right.
Number
Thank
7.
you.
Number what?
7.
Oh, 7. This is 24 CR 00820F. Maurice Hager, 1 count of simple battery pretrial.
2020 probation. 2020 armed robbery, possession of a firearm during a commission. That was dismissed. He had a 09 armed robbery arrest. According to the GCIC I had, he's wanted out of Henry County and Forsyth. That's all.
Okay.
Yes, Your Honor. So on yesterday, December 20th, 2024, officers were dispatched to Riverwood Lane in Roswell, which is a part of Fulton County, regarding a dispute, a domestic dispute. Officers made contact with Nazaria Washington. That's spelled Nazaria. They made contact with Miss Nazaria Washington and Alyssa Brown. Alyssa is spelled AllY ISA. Brown, common spelling. They informed the officer that the defendant and a Miss Love Olten is spelled OUTEN, were in the apartment fighting. Officers entered the apartment to see the defendant with blood on his shirt. They described him as being in an excited state and that he was yelling. The officers detained the defendant so they could investigate what was going on. Miss Washington and Miss Brown told officers that they were in their room when they heard arguing coming from Miss Love's room. And when they went to check to see if she was okay, the defendant shoved Miss Washington against the AC unit, Your Honor. Our office was not able to get in contact with Miss Washington today. However, I would still like to sound for her just in case. The state's recommendation would be a $3,000 surety bond for the defendant to complete 4 hours of anger management, as well as to have no contact with Miss Washington and to stay away from the incident location, Your Honor.
Is it no further contact with both? Are they both victims, Washington and Brown, or?
No, it's just Miss Washington is the victim.
Brown, I guess, was a witness.
Yes.
Maybe. Okay. All right. PD Gaddis.
Yes, thank you, Your Honor. Mr. Hager is 33 years old and has been a lifelong resident of Georgia. He's expressed he has numerous family members who live here, including a daughter. He worked up until recently, he was working in residential maintenance. My understanding is, however, he has been unable to work due to an injury that he sustained. My understanding is that I've already discussed with him the possibility that he would have to have no contact with Miss Washington. He's expressed to me that's not going to be an issue. He has other addresses that he could stay at. There are ways that he can avoid contact with her. We would just ask that, Your Honor, considering that he is not currently employed and his injury would prevent him from maintaining gainful employment, consider a UJR or just a bond on the lower end.
Considering the allegation situation, I'm still not very clear on it. Guess they were all living in this apartment, renting out various rooms. Is that kind of what we think?
I'm not sure. I took it more that he was there with Miss Love Olten, who the report says is his fiance, and they were engaged in a disagreement when Miss Washington and Miss Brown came to check on her. They got into a dispute, and that is when the defendant shoved Miss Washington. Miss Washington is Miss Love's daughter.
That was my understanding as well.
Oh, okay. I get it now. All right. I'm going to order that $3,000 surety bond. No drugs, alcohol, weapons, or guns while on bond. No further contact with the victim, Ms. Washington, and to stay away from that incident location on Riverwood Lane in Roswell. And that should be the order of the court.
Position number 9, Mr. Lewis.
I'm so sorry again. Who is,
9.
okay, okay.
This is 24 CR 008249E Jimmy Hood, charge of 1 count of simple battery. Pretrial.
49, resident of California. I think it says San Bernardino. 2024 simple battery, 2023 disorderly conduct conviction, 2019 FTA, 2018 trespass conviction. That's it.
Now, brief facts of the case is that on December 20th, 2024, the officer responded to a fight in progress call at the location of 240 Peachtree Street, Atlanta, Georgia, here in Fulton County, Georgia. The officer met with the victim, Miss Kimberly Williams, traditional spelling, and a witness, Mr. Marcus Porter, traditional spelling, who advised that the defendant who was on the scene had just punched the victim. The victim advised that she was scrolling on her phone, and the defendant walked up to her and asked her who she was talking to, and then punched her on the right side of her face near her ear. The witness, Mr. Porter, advised that himself and another male had to grab the defendant and restrain him till the police arrived. The defendant admitted to slapping the victim. The victim stated that she was tired of dealing with the defendant and that he was accused of hitting her in a previous encounter. The victim advised that she did date Mr. Hood, but they had never lived together and did not have any children together. The victim advised that she wanted to press charges as a result of the incident. Your Honor, I believe pretrial has already told us of his 49 arrest, one as recent as March 7th, 2024 for a violence-based charge, which is simple battery here out of Fulton County. It is the same victim that ultimately resulted in a dead docket in July. However, the request from the state is a $2,000 surety bond and no alcohol, drugs, or weapons. And absolutely stay away from that victim being listed again as Kimberly Williams. No contact with that victim, and the completion of an anger management course. If we could sound from Ms. Williams in accordance with Marcy's law, that'd be greatly appreciated. Unfortunately, our office was not able to get in contact with her. Nothing further from the state, Your Honor.
All right, Kimberly Williams. Nope, don't think she's here. PD Melnick.
Yes, Your Honor. Sorry. Your Honor, so I speak to my client and I did inform him that if court is to grant him any type of bond, it would have a no contact provision on it. He does have a residence that he can stay at 420 on Cortland Street. He is employed. He is a chef in Norcross, Georgia, and we are asking for a signature bond on this case.
All right, I'm going to order the $2,000 surety bond. I'm going to order no further contact with Kimberly Williams. I'm going to order that he stay away from 240 Peachtree Street. I'm not sure that location. Is there an apartment number or anything?
It's not listed in the warrant, Your Honor, but I can do some further investigation.
Okay. No further contact with Kimberly Williams. No drugs, alcohol, weapons, or guns while on bond. And I think that'll be it.
Position number 10, health.
Was there a stay away in there? That he said he had to research something.
That is correct.
Yeah, stay away from 240 Peachtree Street. Didn't know if there was an apartment number or anything, but stay away from the location, the incident location, 240 Peachtree.
Position 10, Huff.
24 CR 008252J. Not sure how to pronounce the first name, Mr. Huff. Charge of 1 count of battery family violence. Pretrial.
23. Got an open pandering out of Cobb. Open case out of Birmingham for assault. Open robbery and assault out of Jefferson County, Alabama. 2024 obstruction, NOLO. 2020 battery conviction, another 2020 battery conviction. 2019 FTA probation, 2017 probation. 2016 battery DV conviction, 2015 disorderly conduct, simple battery conviction. That's it.
Your Honor, I will give you the facts of both of Mr. Huff's case. The first one that came as the result of October 22nd, 2024 is as follows. The victim reported to Atlanta Police
And 1
Department.
second, you said 2 cases?
Yes, he has 2 cases.
Okay, that's what I want to address before y'all guys got deep into the conversation. There's only one charge on the counter, and I see there's another charge on his booking screen, a battery, but I only got one. So did y'all file down a separate case, 2 case? I'm
We-
kind of confused,
We did. One moment. Let me look at the
and I don't have the other case.
Yeah, I was gonna say, we don't have the other.
I'm not on notice.
There's 2 charges on the booking screen, but there's only one case on the counter with 1 charge.
Right.
Both of them should have been filed down, but let's see. Yeah, both of them would have been filed down. They're somewhat interwoven in terms of addressing the notice issue.
I see the charge now in our queue, but I don't know when it came in.
I just resubmitted it just to be on the safe side, but they were both sent in.
Okay, so there's supposed to be a separate case number on this, so it's be 2 cases.
Yes.
Ms. Rogers, I know you're on the line. Is there any way that you can initiate that other case number for me, please?
I'm not.
I'll go ahead and initiate it.
Okay, I appreciate that. Thank you. And just type in the chat or email me with the new case number for the other charge.
I'm not on notice of this other charge. I don't know anything about this.
You would have been on notice because I guess both of them were on the pull sheet. And then in addition to that, the warrants are inside of the jailing screen. And so I believe you do have access to that. And so you were able to pull up both of those warrants. And so that would be the notice, the effective notice that he was charged
Okay, I'm
with.
not trying to argue. I just don't have notice about it, and I don't want to talk about something I don't know about. Okay, I'm sorry. I'm not
Okay.
trying to argue.
That's fine. I can read the facts to you if you'd like.
I don't want to be
They're
read
interwoven.
facts. Just can you email it to me, please?
Email, what would you like me to email to you?
What the different reports are, the different numbers are, please.
Okay.
Okay, thank you.
When you say different numbers, you mean the different CR numbers?
Yeah, I'm sorry.
Okay, the second CR number apparently has not been issued yet.
Can you email me the 2 different reports, please, so I can look at them?
The 2 different warrants, the warrants are inside the system.
Can you email them to me, please?
Okay, sure.
And can we continue this case so I can look at them, please? It won't take me long.
Okay, we can come back to this case, I guess.
Okay, we'll come back to Mr. Huff.
I've sent the warrants to Ms. Melnick, Mr. Thomas.
Thank you. I
Okay.
just want to look at them.
So who we going to now?
Courtroom 2.
Let's go to position number 11 till they get him ready.
Okay. This is 24 CR 008245H. Abdurrahim Jameh, charged with 1 count of willful obstruction and 3 counts of terroristic threats and acts. Pretrial.
Second. He was arrested this summer for battery cruelty to children. That was a pretrial case. They closed it because I think he's in diversion. And Odyssey, it said inactive on his case. I'll let the state expand on that. That's it. Second
Okay.
highest.
All right. Brief facts of this case is that on December 19, 2024, at the location of Log Haven, Loghaven Drive, in Atlanta, Georgia, here in Fulton County, Georgia, the officer responded to a dispute call. Upon arrival, the officer spoke with one of the victims, that being Miss Rachel Miracle, Rachelmiracle, who advised that she was in a dispute with her son, the defendant, and where he assaulted her. She was in that dispute on December 16th, 2024. The victim, Miss Miracle, stated that the defendant came back to the location and climbed through her bedroom window and locked himself in her daughter's window and locked himself inside. The victim stated that she asked the defendant to leave the room multiple times, but he would not come out of the room. The victim stated that she told him that she was going to call his father, Mr. Jollow, Jallow, Lamin, Lamin. The victim stated that the defendant stayed inside the room until Mr. Lamin arrived. The victim stated that when Mr. Lamin arrived at the location, he attempted to speak to the defendant and to get him to come out of the room. The victim stated that when the defendant eventually did finally come out of the room, he became aggressive and disrespectful towards herself, Mr. Lamin, and his younger brother, listed as Rahman, Rahman, Jammeh. The victim stated that the defendant threatened to fight all of them, which she did not want to happen. The victim was able to provide a video to the officers where the defendant was seen threatening Mr. Lamin, her, and Rahman. In the video, the defendant was seen wolfing up at Mr. Lamin and Rahman, the brother, as they were speaking to him calmly and trying to get him to calm down. The defendant continued to jump at them and told Mr. Lamin, Miss Miracle, and Rahman that I'll beat your ass, I'll beat your ass, I'll beat y'all's ass. The defendant actively resisted being detained when officers arrived. Your Honor, I do believe that my office was able to speak with Miss Miracle and Mr. Lamin. So if we could sound for them in accordance with Marcy's law, I do believe that they may be on today. If we could sound for all three victims, a matter of fact, Your Honor. But the request from the state, and this is again based on what we had listed as an open battery family violence case where Miss Miracle was the victim. I believe pretrial said that it's somehow closed, but it was a pretrial case that was given a $4,000 pretrial signature bond at level 2 by Judge Law. He was instructed to have no further violent contact with Miss Miracle, as we see he violated today. He was instructed to complete a 24-week DVIP program within 30 days upon release. We're not sure if he actually completed that.
So, Brent, let me chime in. So it said inactive, but I did see a pending court date for January.
Okay.
So I don't know if that's a status or what, just so you know.
Okay. Does pretrial intend to come off of his bond possibly, or is that
Well,
what
they stopped supervising him, I think, from what the note said when he went to diversion.
Okay, I completely understood. And so the request from the state at this time, Your Honor, is an $8,500 surety bond for him to have no alcohol, drugs, or weapons, for him to stay away from that incident location, for him to have no contact with all three victims, and for him to complete an anger management course. And I do believe that at least 2 of the victims are on today. So if we could sound for them, that'd be greatly appreciated.
So we have Rachel Miracle and what's the other?
Mr. Lamin, Jallow Lamin.
And then what was the third victim?
And the third victim's last name is spelled Jammeh. First name is spelled Rahman.
Okay. All right. And so Miss Miracle, do you wish to address the court today?
Yes, I can.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. And are you in fear of Mr. Is it Jama? I'm not sure how to pronounce his last name.
Jame. No, I'm not.
Jame. All right. Do you want to have any further contact with Mr. Jame?
Yes.
All right. And your relation to Mr. Jame is?
His mother.
You're his mother. Okay. All right. And he lives with you?
Yes.
Okay. All right. How old is your son?
He just turned 18 last month.
Just turned 18 last month.
Mhm.
Has he graduated from high school?
He just got his GED last week.
All right. I don't have any further questions. You can
I
mute
have
yourself.
one. Is
I'm
it a
sorry.
way that he can like get like some mental like health evaluation or something like that?
If that's what you're asking for us, we can talk to his attorney, see about that.
Yeah.
Okay. All right. Thank you.
Mhm.
Does he have any diagnosis? I'm
Has he
sorry.
ever had a diagnosis, Miss Miracle?
No, because I tried like 5 different times to try to get him to go, like just for me, and he didn't want to go. So that's why I was trying to see if you guys can make it mandated for him to
Okay.
see. I think like he might need that.
Okay. All right. Go ahead, PD Melnick.
Yes, Your Honor. He cannot go into mental health court unless he has a diagnosis, and he has to be approved by the solicitor. So he doesn't have a prior diagnosis. However, it could be part of the court's order that he contact River's Edge. I have contact information to schedule a mental health evaluation. Sometimes diagnoses occur at this age onset. If you don't know, if you know what I mean.
Mm-hmm.
So that might be more beneficial to order that and to start exploring that.
Okay.
So we would ask for a signature bond so he could get out, and we have no objection to that being part of the order.
And I'd just like to notate that at least one of the victims does have an objection to a signature bond and would like for the court to know that this is the second time that he's broken into the home.
Okay. Does he have anywhere else he can go stay, Miss Miracle?
No, he doesn't.
My only concern, ASG Pierre Thomas, is that he's 18. I don't know if he's working or has the ability to go anywhere else at this point, given his age, and I'm assuming lack of a ability to do it. And does the other victim live in the home with him?
All indications are yes.
Miss Miracle, are the other two victims? We want to make sure that the victims are going to be safe, including yourself. And so the other two victims are in what relation to you?
One is my oldest son who lives with me, and his father doesn't live with me.
We have to ensure the safety of all victims involved. How can we do that?
Let me just ask, the person that does not want the signature bond, is that someone that he lives with? Because we could put that part as a no
That
contact.
it was. I thought they said.
I'm sorry, the father does not live at the
So
location.
we could have a no contact with him, and then he could go back and stay with the mother and get the evaluation.
Yeah. All right, let's do that. The state was asking for a $500 surety bond. Was that correct? I mean, yes,
$8,500.
8,500. Didn't read my own writing. All right, I won't go that high with it, but I will. I am concerned about the facts and the allegations, obviously, and that this happened barely 24 hours ago. So I want to make sure that we're addressing the problem and that everyone will be safe going forward and hopefully get some help to make things safer. So I will, on the willful obstruction, that will be a $2,000 signature bond through pretrial. And then the others will be 1,000 on each of the terroristic. So 2, 3, 4. So it'll be a total of $5,000 SOB through pretrial, level 1. And I want to order the MHET.
Hold on real quick with the level. Hold on. Let me look
Okay.
at something.
Okay.
Yeah, it need to be level 2. I mean, technically his case is still open because he goes to court in January in front of Judge Taylor
Oh, okay.
for a
So we'll do
status
it
conference
level
hearing.
2.
But
Right, level 2. Can does the mother need to co-sign? He's just a month out of 18.
that's your call.
Miss Miracle, can you come down to co-sign?
I can't. I don't really know much about all this, like bond and stuff. Did I mean I have to pay?
Who co-signed the first time he got out?
I did, but it was like a signature bond. They said.
That's what this is, but it's the pre-trial.
Oh,
It's a
I just
signature bond,
don't know nothing about all of this.
not a surety bond. It's a signature bond. through pre-trial.
Okay. Yes, I can do it.
All right. Anything else? Oh, no drugs, alcohol, weapons, or guns while on bond. Mr. Jamay. So make sure of that. And to be compliant with any recommended treatment and medication. Must comply with that. All right. Anything else, counsel?
Nothing further from the state, Your Honor. Thank you.
Thank you.
Number 15, Mr. Paul Phillips.
'24 CR 008239F. Paul Phillips, 1 count of criminal trespass, pretrial.
9th arrest on probation for shoplifting and trespass out of state court. He just got put on probation on December 10th. 2024 FTA, 2024 unlawful conduct during 911 call. That's it.
Okay.
Your Honor, on December 19th of this year, officers responded to a refusal to leave call at the Chevron gas station on 6129 Old National Highway. When officers arrived, it was reported that the defendant had previously been issued a criminal trespass warning on December 14th of this year, and that he had returned to the location. Your Honor, the warrant noted that the defendant had violated the criminal trespass warning 6 times in a matter of 3 days. So just to give you a quick timeline, on December 14th, he was issued a warning. On December 18th, he was arrested for violating the criminal trespass warning. And then on December 19th, this case, he was arrested again for violation of that. So given this, Your Honor, the state's recommendation is a $500 surety bond to stay away from the Chevron gas station at 6219 Old National Highway, as well as no alcohol, drugs, or weapons while out on bond.
PD Geddes.
Yes, thank you, Your Honor. Mr. Phillips has lived in Georgia since he was 6 years old. He's now 40. He unfortunately does not have stable housing or a stable employment. He is currently homeless. He has expressed to me that he has no issue with staying away from that address. Your Honor, I would just ask that the court take into account the lack of stable housing, the lack of income, and give him a signature bond. I have a concern that short of a signature bond, he would not be able to leave custody.
Right. Got a few concerns here. So I'm going to ask that there be a social worker visit to him to help with employment and his housing challenges. But I'm going to order the $500 surety bond. I'm going to order a stay away from the Chevron 6219 Old National Highway. And no drugs, alcohol, weapons, or guns while on bond.
You said the amount was 500?
Yes, 500 surety.
Thank you.
Mhm.
Next is number 16.
Okay. 24 CR 008240G, Joshua Player, charge of 1 count of simple battery, pretrial.
21, 2023 Semper Battery, 2018, and 2 2017 probations, 2015 ag assault conviction, 2014 simple assault giving false name conviction, 09 disorderly conduct battery conviction. That's all.
Okay.
Your Honor, on December 17th, 2024, officers arrived at 731 Peachtree Street regarding a physical dispute. Officers met with Joseph Cook, who advised that he walked outside of his apartment at 855 Peachtree Street, around that area, and someone hit him in the back of the head. He told officers that he blacked out for a second after the attack. He noticed a black male running and chasing a woman nearby. Mr. Cook told officers that he determined that this was the person who hit him. And so he followed him and waited for the police to arrive. When officers arrived, the man was identified as Mr. Joshua Blair, and he admitted to hitting someone over a property issue. Officers were able to review surveillance footage, and it showed Mr. Cook, the victim here, walking out of his apartment, walking by or past the defendant, and then the defendant turned around and struck him in the head, Your Honor. So for these reasons, the state's recommendation is a $3,000 surety bond. We're asking that he completes 4 hours of anger management, to have no further contact with Joseph Cook, as well as to stay away from Peachtree Street, as well as no alcohol, drugs, or weapons while out on bond. I would like to sound for Mr. Cook. We did not get the opportunity to speak with him, but I would still like to sound for him.
Mr. Joseph Cook. Joseph Cook. All right. Go ahead, PD Geddes.
Thank you, Your Honor. Mr. Player has lived in Georgia since he was 11 years old. He's now in his 30s. He's expressed to me that he does have his mother and father who live in DeKalb County. Unfortunately, they are not able to house him. My understanding is that he resides primarily in a shelter based out of DeKalb. He relies primarily on Medicaid for income. I have similar concerns to the last case, Your Honor. I would ask that you consider implementing a UJR. We don't have any issue with the conditions that the state is asking for. I just want to make sure that he is able to get out.
With 21 cycles. This is on Mr. Player, right?
This is Mr. Player, Your Honor.
And what is his most recent?
123 Semper Battery.
I will order a $3,000 surety bond. Stay away from that 731 Peachtree Street location. No further contact with Joseph Cook. And no drugs, alcohol, weapons, or guns while on bond. That's it. Next. Are we ready for, who do we have left? Just the case with the two, Mr. Huff?
Sure, number 10.
We didn't do Huff?
No,
My
I
bad.
didn't, we didn't come back to him.
Oh, okay. I know I had
Yes, Your
crossed
Honor,
it out.
I was able to review those.
Yeah, have you had a chance? I just
Yeah, I
saw
did.
the other case come through.
Yes, Your Honor, I did. And I want to thank Ms. Falk for being sending it to me. The one of them was blurry, so it took me a few minutes to figure out what was going on, but that's fine.
All right, Mr. Huff, position 1024 CR 008252J, where he's charged at one count of battery family violence. I had here 23 cycles. Let me go over to the other case, which is 24 CR 00825. No, that's the same one, 2J. What's the add-on case number?
No,
Isn't
the
that the
add-on case
same?
number is 024 CR 0.
Oh, 56. I'm sorry, it's very
56.
close. I
Yeah.
see. 8256J. The first one was 8252J. I'm sorry, so it is different number. And what is the charge? I just pulled it up. Hold
Both of them are
on.
battery family violence.
Oh, both are the same. Okay. I'm just looking at the add-on calendar now. Sorry. All right. And I think I still have, you all want to briefly do the history. And I had cases out of Birmingham for assault and
All that.
pandering. Yeah.
Huh? Pandering. Hold on.
I thought, nope, didn't I have
He
pandering?
did have a pandering.
Yeah, Marietta.
Okay.
All right,
I
that's
thought so.
23 open. You want me to go over it? Or you good?
Briefly, I think I'm good.
All right.
Okay. Go ahead, State.
All righty. Now the cases are intertwined, but I'll read the facts separately, and I'll start with the case that's alleged to have happened on October 10th. I'm sorry, October 22nd, 2024. But basically, the victim reported to Atlanta Police Department on the 23rd, an incident that took place on the 22nd. The victim advised that the previous day that she had been drinking, and when she met up with the defendant, the defendant had been drinking when they met up. The victim advised that the defendant got upset with her and a verbal dispute began. The victim stated that he had her call a guy and read from a script that he prepared or whatever. She advised that this was his way of trying to get the guy to say something to incriminate her. When nothing incriminating was mentioned, the victim advised that the defendant began to yell at her and began to punching on her. She advised that the defendant kept her phone and would not let her have it back. She stated that he began to verbally repeat, "You gonna leave me." The victim advised that she eventually succumbed and submitted, and that they spent the night together. She advised that it was not until the defendant assaulted his father, which is the other case, that she made a outcry about the assault that had happened the night before. The victim had visible swelling to the left side of her head. The two have been living together in the same household for a month. The victim's name in this case is Angel Brown. I will move on to the next case, Your Honor. The facts of that case are as follows. On October 23rd, which is just the day, I guess, after the original incident, or the first incident, officers responded to 2690 Metropolitan Parkway Southwest on a person injured incident that occurred at 2745 Old Hateville Road, Southwest Atlanta, Georgia, here in Fulton County, Georgia. That is the incident location for the first case as well. The victim had been punched with a closed fist and struck in the head by his son, the son being the defendant in this case. They share the exact same name, which is DJUAMIEL HUFF as the last name, which caused a laceration to his left eye that the officers observed. An officer also observed the eye was bleeding profusely. The victim stated that his son's girlfriend, Angel Brown, the victim in the other case, called and stated that she had been in an altercation with her boyfriend and that she needed help with moving her property out of their shared apartment. The victim rented a U-Haul, the victim being the father, rented a U-Haul truck, and they went to the apartment to start moving when the defendant seemed surprised to see his dad. The defendant asked the dad, "What are you doing here?" At which point he punched the father in the face and started the altercation. The defendant fled the scene while the victim and Miss Brown relocated to the Metropolitan Parkway, where they ultimately met up with the officer. The victim was treated on the scene by Grady EMS. The victim stated that his son was on drugs and needed some help. Miss Brown advised that to the responding officer that she had reported the incident involving the defendant to another officer earlier that morning. Your Honor, again, I want to point to the criminal history, which is it may just read, and I'm being facetious when I say just, but it may just read as 29 cycles, but it is sprawled across at least 3 states. It is to include aggravated assault. It is to include a battery family violence conviction that was ultimately pled down to battery in Clayton County. It is to include an actual battery family violence conviction out of Muskogee County as recent as 2017. The state sought to have this matter upgraded to a felony, and we're still in the process of doing so. However, we accused it today to avoid any sort of Riverside issue. The convictions go on. There is a 2022 battery conviction out of Muskogee. There is a 2021 possession of a firearm by a convicted felon conviction out of Muskogee. Originally, that was charged, or he was arrested for pointing or aiming a gun or pistol at another with that charge. There is a 2021 battery conviction out of Muskogee as well as there is a March 4th, 2024 willful obstruction of a law enforcement officer conviction out of Clayton County, to which he received 12 months of probation that was suspended and 30 days to serve in custody. He would have been on probation at the time of this offense, Your Honor. I think that we heard about the arrest for theft by receiving and the arrest for pandering and the battery family violence arrest that was ultimately null prost, which is a separate charge, but it was a battery family violence arrest with battery and 4 counts of simple battery out of Clayton County in 2015 that was ultimately null prost. And then as it relates to his other charges in other states, there's a 2011 wave sounding charge. Wave sounding is because it's a major case. That was and another arrest for weapons carried concealed and accessory after the fact. There is another arrest, a 2015 arrest for assault, and a 2015 arrest for assault and robbery. Given all of that, Your Honor, it is quite clear that the defendant is not taking this matter seriously. We are of the position that this is, in fact, a felony. We're just waiting to hear back from the DA's office at this point. But the recommendation from the state would be a similar recommendation on both cases. It would be $10,000 surety bond on each count of battery family violence, which the state contends is a felony. No alcohol, drugs, or weapons, a stay away from that incident location, no contact with either victim in this case, and the completion of a family violence intervention program. If we could sound for Ms. Brown and Mr. Huff in accordance with Marcy's law, Your Honor, that'd be greatly appreciated. There is nothing further to add from the state at this time.
All right. Ms. Brown, Mr. Huff, I'm sorry, Ms. Brown and Mr. Yeah. Do we have either of them on the line? Nope. All right. PD Melnick.
Mr. Huff. Yeah. I'm so sorry. What'd you say?
The Huff is on the line.
Hold on. I think we do have Mr. Huff. Mr. Huff, do you wish to address the court today? Yes or no?
Yes, I do.
Raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you in fear of your son, Mr. Huff?
No, I'm not.
Do you want to have any further contact with him?
Yes.
Okay, does he live with you?
Yes.
Okay. And how old is your son?
32.
Okay.
Could I say something, Your Honor?
Briefly, but this is not his trial. This is just his bond
Okay.
hearing.
Him and Angel, this case was amplified by the police officer. I never wanted him charged with hitting me. I was him and her were both drunk the day before I had went over there, and I took their keys from them. And what it was something she had found in his phone or something like that that started the whole incident. But earlier that day, the police officer concluded that nothing happened with him and her and let her go. The officer who came when I called the ambulance, he's the one filed the report. And I told him I didn't want to press charges. Miss Brown told him she didn't want to press charges either. And Miss Brown lives with my mother right now. So we don't want him charged. This was amplified by the police officer.
Mr. Huff, if I may ask, and I'm a representative of the state, why did you call the ambulance?
I called the ambulance because see, I didn't want them charged because I put my hands on him first. I didn't want them, either one of them driving. So it's not like he hit me for he really was like trying to get out the door. I told the police officer that I didn't want him charged. He went on and did it himself. Amplified this case. This case was amplified, and her and him still go together. If he had a bond, she'd probably be the one to bond him out. So this is a waste of the taxpayers' money. I told the officer, I told the victim's advocate, she told the victim's advocate that she didn't want to charge. The only reason she changed her number because the victim's advocate was threatening her like she could get charged with something when we told that officer initially that we didn't want to charge him with anything. They had too much to drink the night before. That's basically what it was. And I know he has a history, but he was driving a cab. He had just started the job driving a cab when he was arrested. She was in the cab with him. So it's just a waste of time. He has made some changes for as being sober, and he goes to AA. So I think that this case is amplified. I'm not scared of him, and trust me, she's not scared of him either.
And Your Honor, I just notate that our victim witness advocate has not spoken with the victim in this case, and
She spoke with both of us. She spoke with both of us. It was like a month ago. Well, right after it happened, they called me and they called her. And
do you remember the person's name you spoke with?
Her name was Detective Brown or Brown, I think. She called and she was like, "Well, we could still."
Well, hold on. I don't want to hear the conversation. A detective would be with the police department.
Well,
there are no detectives with the solicitor's office.
She said she was a victim's advocate. She called my phone. She left me messages, and I didn't hear nothing else from him until today. We actually thought it was over with. Me, Angel, and him, we thought it was over with. Till he got that job driving a cab. The first day he went out, he got pulled over by a police officer.
Okay.
And I guess, Your Honor, if I could just point out that one of the major concerns that we have is one of his arrests here in Georgia is for false imprisonment. And the facts that were alleged in the first incident was eerily similar to the concept of false imprisonment, where the victim even said that she almost felt coerced and she stayed there. She submitted in an effort to, I guess to go along, to get along. He took her phone and he tried to prevent her from doing several other things. In addition to that, he wrote a script for her to call someone, which is eerily similar to the level of manipulation that is constant in these domestic violence situations. And so outside of his criminal history, which is a ton of gun, a ton of battery, a ton of violence, we just like for the matter to be taken, into account that this may be a situation of intimidation.
Your Honor, can I say something?
Briefly.
Once again, this is amplified. They were just high on weed and they had been drinking a lot. And I think they had took an ecstasy pill. And she found out he was cheating on her, something in the phone. It was like, I'm not blaming either one of them, but they was just too high. Typical. It happens in the hood. I hate to say it.
No, we don't want to admit that it's typical and happens in the hood.
Yeah,
no.
I'm ashamed to admit that, but people do crazy stuff. But he realized the seriousness of it because I told him they will use your record to amplify it and try to get you more time. Some small can be amplified.
But right now I'm talking about bond. He hasn't been sentenced. He hasn't gone to trial.
I want my charges dropped, and if she need to do something to get hers dropped, she'll get them dropped. I don't think it should go no further than this because She didn't come 'cause she was scared because the lady was telling her like she could be charged if she don't press charges.
Well, and she made a false claim or, you know, and perjury, things of that nature. So they may have been, but it sounds like you were talking to a police detective and they may have advocates there as well. But
Yeah, her
if
name,
if they have detective in front of their name, they're
her,
not with the solicitor's office.
the only
But
reason
but that's not important at the moment for
the
what
only
for
reason I came today, I told him this morning I didn't want to do the court thing or anything like that. Because I thought it was over with. But I know that if I didn't come forward with the facts, that it'll be amplified to another level as if he tried to kill somebody or something, you know?
Well, he's not charged with that. These are
Yeah.
misdemeanors. But as a victim, yes, you have a right to be here to
Yes, I want.
explain. But again, this is not the trial. This is not the forum or the time for that. I'm not here to sort out the facts,
Yeah.
okay? I'm not here for that today.
Yes,
I'm
ma'am.
here to make sure that with his history, he's going to return to court. He's not going to abscond from the state or be there, and that you know,
He's
he's
gonna.
going to comply with the bond conditions.
He's not. He's not. He don't have. He just started his job, so he don't have no money. All this will do is make him lose his job. If he stay in jail, the jail will get paid for housing him. But she's not in fear. I'm not in fear. So it's really no need for him to be incarcerated. And it happened in October. We done
And
moved on as a family.
we'd just like to notate, Your Honor, when we did speak to Mr. Huff today, we asked him for contact information for her, and he indicated that he did not have so. So I'm
She doesn't. She
so
doesn't want. She doesn't want to be contacted because
But
she's.
you cannot speak for her, Mr. Huff. She needs
I
to
know I
speak for
can't.
herself.
I
She
know.
needs to speak for herself.
But she felt like they was pushing her to push a case that she don't want to push.
Well, but when the police are called and they do their investigation, they're the ones that also have a say in determining about the charges as well.
Another officer earlier that day concluded that that incident had no plausibility, right? So
Well,
then,
then they would not have brought charges. So
no,
let me not argue with you back and forth on that because we're wasting time. And that's
yeah.
not what I'm here for today.
Your Honor,
I'm
we
here
don't know if she's the same victim in these underlying convictions.
no, she's not. That's his ex-baby mama.
Okay.
She's
Well,
in
but that
jail.
says he had, but it also indicates he
Battery,
has a,
family violence.
yeah, it indicates a serious problem with females and things of that nature. And these type of charges are all very similar with different females, makes it even worse. Because it just says that he has issues. And so those will need to be sorted out at some time in his life. And he needs to get some counseling and help for that so he can learn to deal positively with women. So I'll say that and I'll move on. Deputy, wow, Deborah Melnick, I've given you another title. PD Melnick, what would you say on behalf of Mr. Huff?
Your Honor, I mean, basically, his
Please
fault.
mute yourself, Mr. Huff.
Okay.
Thank you. Go ahead.
No, Mr. Huff Jr., you are not speaking. Okay, I'm not going to let you speak. No, no, you can beg all you want. No. Anyway, Your Honor, basically, this did happen in October. There have not been any additional incidences. You've heard the father, and so, sorry, you've heard my. You've heard the father, and we would ask for a signature bond, and we have no objection to any type of domestic violence counseling while he's out on bond.
Okay. He's a multi-state offender, which concerns me as well. And the history definitely concerns me. And I will say to Father Mr. Huff that Miss Angel Brown needs to come forward and speak for herself in a environment that would not show that she's been influenced or coerced by you or the defendant, okay? And until she does that, there's nobody else that can speak for her. For all we know, you know, she's being influenced by you all. You're providing housing for her or whatever, and we want to make sure that she's safe. Because even in the hood, people deserve to be safe and not be intimidated or coerced by the situations, okay? And that's what it looks like from the outside looking in. I'll be honest with you. So she needs to speak for herself in an uninfluenced situation, which means she needs to come down to the office by herself. Okay, so that we can make sure that she is safe. And so I'm going to order on the first case, which is the one ending in 8252J. And with that one, the first case, the victim is the dad or Angel Brown?
Miss Brown.
Miss Brown. In that case, I'm going to order a $5,000 surety bond. And with that $5,000 surety bond, I'm going to order this address, this 2690 Metropolitan. Who lives there? Do we know?
I'm sorry, I was struggling. Metropolitan is where they retreated to speak with the officer. The actual address is Hoganville, I believe it was.
Oh,
I can pull it
okay.
up. And it's the address for both locations. She lives there, and so the stay away would be effectively for both cases. It's the 2741 Old Hogansville Road, Southwest.
All right, Mr. Huff, the dad Huff, is that where you live? Who lives at the Hogansville address?
We have it as
You're
both of them.
you're muted. Unmute yourself. Can't hear you.
I live at 602 Tree Crest Parkway. That address, nobody lives there anymore.
Okay, who was renting it at first?
My son and her.
Oh, that's where they were staying?
Yeah.
Okay, and so now you said she lives with you
She
or
lives.
your mother?
Yeah.
Okay. So I'm going to order that Mr. Huff, your son, have no further contact with Angel Brown, even though it happened in October. We're just in December, but I want to make sure that she's safe and not being intimidated. So right now, to make sure that there truly is a long cooling off period and that she's not being influenced or intimidated, no further contact right now while he's on bond. He's to stay 200 yards away from her, and which is 2 football fields. And he's not to contact her right now. No drugs, alcohol, weapons, or guns while on bond. And in the second case with you, Mr. Huff, since you still want to have contact with him, you can do that, but it should be no further violent contact. So I don't care what he's on, what he's taking. If he gets violent with you, he can be rearrested. No drugs, alcohol, weapons, or guns. He needs to not drink. I'm glad he's going to AA meetings. I'm going to put that in the order that he should continue to go to his AA meetings. He should not use drugs and he should not drink alcohol. Obviously, it doesn't bode well for him. And, no unprescribed medication, no knives, no guns, in both cases while on bond. So he can be around you, but not Miss Brown right now. Okay.
Mm-hmm.
And that's until we can sort this out.
Your Honor.
All right. Mm-hmm.
She was intimidated by the police, like pressuring her to press a case that we told the officer initially that we didn't want to press.
Well, you can't say what she doesn't want to do. You can say what you.
I can
Stop
only
saying
say,
we.
yeah.
I need you to say I,
Yeah.
okay? But not we, because when you say we, there throws it back in that you can't speak for her. She
Okay.
needs to say to the officers. Now, if she didn't say to the officers, then they don't know.
Okay.
And they're probably thinking she's intimidated. But you can't keep saying me and she and we don't want to do it. It needs to be I. I don't want to press charges against my son, but she's got to say it for herself. And they have to be convinced that it's true. And if it's not, then they'll do what they have to do as officers. All right. You have a question, Ms. Lewis?
I do, Judge. You didn't say the bond amount on the add-on charge.
5,000 on both, surety. And let's see, on the second case with the add-on, hold on.
You had no further violent contact with the father and continue on AA meetings.
Right. Actually, the conditions ought to be the same on both. And I'll tell you this, with the father, I'll make it 400 instead of 500. 500 on the first one with Ms. Brown, 400 surety on the one with the father.
500 on position 10 and 400 on the
Add-on.
add-on. And the original one.
4,000, did you say 4,000 or 400?
Judge, you said 400, but you
400.
said 5,000 first, so I was
First.
confused too.
That's I'm confused.
Yeah, I was
I meant to say 5,000 and 4,000. I'm
I was
sorry.
like 500 and
I'm sorry, Your Honor.
400.
Can you repeat that with everyone speaking? I can't. What was the final bond?
The bond on the first case, which is position 10, is a 5,000 surety.
Okay, thank
On
you.
the add-on case that's ending in 256J is 4,000 surety.
$9,000 surety for both
Total
charges?
for both cases, yes.
It's a felony.
Excuse me, what was that? Put that was unnecessary?
Anyway, let's move on, everybody.
Judge,
Anything else?
I'll make one more thing clear. The conditions on number
Yes.
10 is no further contact with Angel Brown. That was the only
Right.
condition, and no alcohol, no drugs, no weapons, and to continue on AAA meetings.
Right.
So there's no stay away.
With her, yes, I
But I
said
didn't
that
get
he
the
would have to.
address.
Well, I don't have the address that Mr. Huff can give us the address. He said she was staying with his mother, but I'm going to say that he should stay away from her wherever she lives or works, 200 yards. And if she's at his mother's house, she can give us that address. Or we'll get it from her. And so, wherever Miss Brown is, that
I just put stay away for the resident, the living resident, whatever.
and work address of Miss Huff. Yes, that's sufficient enough. So he shouldn't go to her job and he shouldn't go to his grandmother's house to see Miss Brown because he can be arrested. But he can go to his dad's house, which is a different location on Tremont, I believe he said, or Tree something. He can go to his dad's house, I guess, as long as Miss Brown is not there. Miss Brown is there, then he can't go to his dad's either. Because he has to stay away from Miss Brown, 200 yards.
Got it.
All right. We want to make sure Miss Brown is safe. And again, Mr. Huff, you can pass along the message to Miss Brown. Tell her to come down to the solicitor's office and talk to the victim witness advocate, not to the police department per se, because she's talked to them, but I don't think she's talked to the victim witness advocate at the solicitor's office. That's a different person. All right.
Yes, Your Honor. I will speak with him before he does anything. Mr. Huff, please do not come. I'm sorry. I will speak with you, but do not say anything else. Do not give any more addresses and do not give any advice. Thank you.
All right. Thank you. Next case.
Okay, let's go to number 2. Number 2 is a waiver. Then number 8 is a medical research.
Number 2 still needs a bond.
I just said it's a waiver.
I know.
Right, and number,
I waived his presence.
Wait, what do you mean? What do you mean he's a waiver?
I waived his presence.
Yes.
So we can still do number.
Do you all have a copy of the waiver?
I sent it to.
I got it. I have it.
Okay. And then position 8, Hernandez, is the medical reset until Monday.
Right, but do we have a bond on position number 2?
We haven't argued it yet.
Okay.
And 2, what are we doing to 2? Oh, 2 we are. Is 2 a waiver or no?
He waived his presence, Your Honor, but not the actual bond argument.
Correct. So 2 and 8 are waivers. Okay.
No, eight is reset medical, Judge.
Oh, I'm sorry. I have it
judge.
here.
Yes.
I have it
It's gonna be
written
on the SDA for Monday, the 23rd.
Yep, I have it. Sorry. All right, we ready for 2? And that's the last case, I believe.
Yes,
I hope so.
I was looking through my calendar as I was talking. All right, this is 24 CR 008237J, Zachary Collins, death by shoplifting. Pre-trial.
Yes, yeah.
19 total. He's wanted out of Coweta and Fayette County. Blunt, do you have a felony bond amount for today? I think he went to felony as well. 2021 FTA, 2021 trespass conviction, 2021 fleeing an officer conviction, 2 probations from 2021, 2020 possession of a Schedule 1 controlled substance conviction, 2016 interference with government property conviction, 2015 probation, 2 theft by taking convictions, well, 3 from between 2015 and 2014. 2014 entering auto possession of a Schedule 4 conviction. That's all.
Thank you. State.
Your Honor, and I also just want to say he does have these 2 open arrests or 2 open pending felonies here in Fulton County, the theft by shoplifting. That's from October 7, 2024 arrest and a December 19, 2024 arrest for possession of drug-related objects and possession of cocaine. Your Honor, this offense took place on June 8th, 2024 at the racetrack at 7845 Senoia Road in Fairborn, Georgia, here in Fulton County. Officers recalled when they spoke to an on-duty employee who stated a black male wearing a cap, gray shirt, and blue jeans arrived in a Dodge Charger with a temporary tag and had shoplifted or had taken multiple food items valued at about $20. At some point in time, the employee stated that the male comes about every day to steal the food. The officers were able to locate Mr. Collins through the temporary tag in that orange Dodge Charger, who was registered to his girlfriend's son, but they were able to match Mr. Collins with a photo to that surveillance video that they were able to see. Your Honor, I am asking for a $3,000 surety bond, anti-theft, of course, stay away from all racetracks in Fulton County. Also, no alcohol, drugs, or weapons.
All right. You be mailing it?
Yes, Your Honor, I am going to ask, I understand the state's argument, but I'm asking for a signature bond on this case so that the felony is going to hold him, and if it's holding him, then I'd like for him to be able to move on to the other counties to handle those. I think he's got bigger fish to fry.
All right. I'm going to order a $2,000 surety bond. I'm going to order stay away from all racetracks in Fulton County. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And that should be it. Anything?
Excuse me, Judge, in felony court, he received $100 on one case and then a UJR on the second case.
$100 in UJR?
Yes, ma'am.
Which, I'm sorry, I didn't.
That was for the felony case earlier today.
Let me check that because that doesn't sound.
I know.
Not on a felony.
No, they order bonds like that. They do.
Sometimes
depending on what the charge is.
I'm still gonna check.
That's fine. I'm just letting y'all know though. They do that just so y'all know though.
We just looked at the calendar. That's how we knew.
Yes. Wow. Okay.
I mean, it's like somebody getting a $10 cash bond for a trespass here who got, you know what I'm saying?
Yeah, if that's the case, so that would the court still consider my argument for signature bond so that that he can move on to the other counties and handle those cases.
Are they coming to get him? I mean, is his
he's a hold.
State, what's your comment on a signature?
Absolutely not. I mean, this happened in June of 2024. He picked up a case in October of 2024, a felony, and in December of 2024. No,
But those were not theft charges.
Yes, they were. One of them, October 7th, was a theft charge when he went to Lowe's and he stole $690 worth of products from Lowe's. So that is a theft charge.
I said I was sorry. I said I was sorry. I did not hear you say that.
Okay.
All right, I'll stick with the 2,000 surety.
So we're gonna give him okay, whatever.
2,000 surety. And then after he does that, he can go deal with his other cases.
Your Honor, I think this is the last one. Can we go over the calendar so we have all the correct amounts?
Yeah.
Thank you.
Just briefly, Your
I
Honor,
got
we're
you.
missing Michael Weinstein.
No, he got
Um,
bailed out. There's two that got bailed out. The ones you probably getting ready to say the names, they bailed out.
Weinstein. Okay. Who was the other one? You know?
The other one was start the F. Finney.
Okay, I know you're talking about. Okay.
You talking about? You know what I'm talking about?
Yeah, I do. Okay.
Hold on, I had
No,
it.
we don't.
His name was Bryant. Bryant Fanny. He bonded out, and the Weinstein bonded out.
Spell the last name, your spelling of the Brian what again?
His last name is Fanney. First name is
Okay.
Brian. Brian.
Gotcha.
Bryant. And the other
Thank
one
you.
is the one she just mentioned,
Right.
Weinstein.
Weinstein.
Michael.
Okay.
He bonded out. Both of them bonded out. Okay, let me go over the calendar. Everything here. Okay. The add-on calendar, we all know there's a $4,000 surety. This should be reset. All the cases are reset to the SAP for January the 7th, 2025. So I don't have to repeat that. January the 7th for 2025. That's a tongue twister for me. So we all, when I say SAP, that's the date. Position number 1 is a $2,000 surety reset for SAP. Position number 2 is a $2,000 surety reset for SAP. Position number 3 is a total of a $6,000 surety reset for SAP. Position number 4 is a total of a $4,000 SOB through pretrial level 2 reset further notice. Position number 5 is a total of a $6,000 surety reset for SAP. Position number 6 is a total of a $3,000 SOB through pretrial level 1 reset further notice. Position number 7 is a $3,000 surety reset for SAP. Position number 8 is reset for the SCA counter for Monday, December the 23rd of 2024. Position number 9 is a $2,000 surety reset for SAP. Position number 10 is a $5,000 surety reset for SAP. Position number 11. Position number 11 is a $5,000 SOB through pretrial level 2 reset further notice. Position number 11, position number 12 is a $1,600 surety reset for SAP. Position number 13 is a $500 good bond reset for SAP. Position number 14 is a $3,000 SOB through pretrial level 1 reset further notice. Position number 15 is a $500 good bond reset for SAP. Position number 16 is a $3,000 surety reset for SAP. Position number 17 is a total of a $600 surety reset for SAP. Position number 18 is a $500 SOB through pretrial level 1 reset further notice. Position number 19 is a $6,000 surety reset for SAP. And that completes the calendar. Any questions or corrections?
Nope, think we got them all.
That's all. Okay,
All right.
I'm getting those orders.
Everyone enjoy your holiday.
Everybody, happy holidays to you if I don't see you. And happy New Year's too.
Oh, Happy New Year's too.
Yes.
Somebody's taking a long time off.
No, I'm not. I wish, but I'm just saying if I don't see y'all.
All right, you all take care.
Everybody
All
take
right.
care. Be blessed.
All right. Bye-bye.